what are some typical types of counterfeiters? Brick and mortar stores, like flea markets, street sellers, for example, New York City's Chinatown. This is a stagnating breed of counterfeiting because people are moving to online shopping. From 2002 to 2015, online retail sales have increased from $42 billion to $256.1 billion. Counterfeiters online and on the internet remain anonymous. Websites can change rapidly, so photos and products are taken down immediately if there is a concern that they might be caught. And the way products are advertised online can be deceiving. So, for example, a legitimate product can be shown online, but the product that you actually receive after you've ordered online could be a fake.
Unfortunately, counterfeiting and policing your anti-counterfeiting efforts is oftentimes a big game of whack-a-mole. You close one offending website down and a new one will open up later that day or the next day. But having an effective enforcement program is absolutely critical to maintaining the value of the mark. And there are ways to formulate enforcement programs that are cost-effective, that are continuous, and that truly police the areas that need to be policed, whether it's brick and mortar or online. It's like a maintenance program for your house. So when you know your roof is leaking, you need to fix the roof or the value of the house will suffer. This is exactly the same thing when it comes to policing counterfeiting. If you know about counterfeiting, if you're concerned about the value of your product or of your mark, if you do nothing about that counterfeiting, the value will suffer and you may lose the ability to exclusively use that mark.
Yes. Okay, so the good news is that the government comes in to enforce against counterfeit goods. In 2008, the New York Police Department raided Canal Street in Chinatown, New York City. 32 shops were closed in a counterfeit triangle. $1 million in counterfeit goods were seized, and significant fines were imposed against the landlords. In 2012, China issued prison terms for counterfeit Croc shoes. $10 million in counterfeit merchandise was seized. There were 17 individuals that received prison terms for 2.5 years each. This is for the producers and the sellers of the goods. $25,000 in fines, and they were convicted of bribery. In 2013, there was a New York councilwoman whose district includes Canal Street, and she proposed criminalizing the purchase of counterfeit goods. This would include a penalty of a $1,000 fine and/or jail time up to 1 year. This would be a Class A misdemeanor.
And one of the important things to note is that this type of preventative measure has already been established in certain countries. For instance, in Italy and France, it's criminal to own, sell, or buy a counterfeit product.
And as you can see, there are some other entities as well. The National Intellectual Property Rights Coordination Center, Immigrations and Customs Enforcement, U.S. Customs and Border Protection, and the Department of Justice, all working to stop the sale of counterfeit products.
And it's estimated that in 2015, $650 billion worth of counterfeit goods were sold both in brick and mortar and online. That's a significant amount of money and a significant amount of revenue that the industry is missing out on.
Okay, so if you are a designer and you would like to file litigation against a seller of counterfeit goods, what are some of the issues? One of the biggest hurdles is personal jurisdiction. Many counterfeiters are located abroad with no bank accounts in the United States, no residences in the United States. Most states' long-arm statutes include tortious conduct like trademark infringement, like New York does. Selling and shipping an item to the forum state is typically enough to establish jurisdiction, according to the Second Circuit, Chloe versus Queen Bee of Beverly Hills, LLC. This is a 2006 case. In addition, alternative forms of service of process are permitted due to the deceiving nature of counterfeiters and often because they provide false names and contact information. So we have an example for you in the Rio Props Incorporated versus Rio International Interlink case. This is a Ninth Circuit case from 2002. The Ninth Circuit determined that there was no abuse of discretion by the district court in allowing service by regular mail or email after initial attempts at service failed against a foreign business entity.
And it's important to note, too, that a brand may be able to sue a foreign actor, even if that actor has no presence in the United States. If the damage or activity somehow is felt or takes place within the United States, even though the foreign actor is situated abroad, it never steps foot in the United States.
Right. Okay. And remember that phrase, likelihood of confusion? We're going to talk about it here in connection with trademark infringement or parody. Lessons from Chewy Vuitton. In this case of Louis Vuitton versus Hot Diggity Dog from the Fourth Circuit in 2007, the court determined that the dog toy conveyed a joking and amusing parody of the Louis Vuitton. Also, another concern is injunctive relief. The importance of temporary restraining orders to enjoin further advertising, marketing, and sale of counterfeit goods. And one of the important factors that will need to be proven is a likelihood of success on the merits. That's one of the elements that will need to be shown in order to get a TRO granted. In addition, another option could be restraining orders for third-party suppliers and domain names. And another thing is that there's often expedited ex parte discovery. This is to help determine the names of the defendants, obtain financial institution information, and to identify the website providers that are selling these counterfeit goods.
And in the issue on likelihood of success on the merits, these cases are often unique, with many noteworthy exceptions and high-profile exceptions. This prong, whereas it may be difficult to meet in other contexts, is often easier to meet in this context because counterfeiters are intentionally trying to confuse consumers. So courts will take notice of that and factor that into whether a brand holder is likely to succeed in the ultimate case.
Yes. Okay. Contributory infringement. This is against secondary actors who knowingly contribute to the infringement, like online auction sites, credit card processors. For example, in Gucci America versus Frontline Processing Corporation, this is a Southern District of New York case from 2010, Gucci sufficiently alleged a claim for contributory infringement against a credit card processor because they knew that the website knowingly traded counterfeit products. And this holding is essentially an incentive to prevent the sale of counterfeit goods. In addition, there could be suits against the offending website, and the Anti-Cyber Squatting Protection Act, the ACPA, provides for this type of action. And it turns over the offending site, results in the seizure of funds, injunctive relief, money damages, and attorney's fees.
And we'll address the ACPA in greater detail in a little bit. But contributory infringement is an area that continues to develop, and it's important because a tenant or seller often disappears, and the landlords often know and turn a blind eye to the type of conduct, the offending type of conduct, i.e. counterfeiting. We recently handled a case for a large international brand where we brought suit against a flea market owner who had a history of supporting and promoting the sale of counterfeit goods by vendors at his flea market. The owner of the flea market was quoted in the press as saying the counterfeiting was not his problem and he didn't need to do anything to stop it, despite the fact that he received multiple cease and desist letters from multiple brands. He had been raided a number of times by both local and federal authorities. He actually charged additional fees to vendors to cover the costs associated with selling counterfeit goods, his legal fees. He charged an entry fee to come into his flea market, which was known for selling counterfeit goods, so that he reaped an additional benefit from the sale of counterfeit goods at his flea markets. Ultimately, he posted signs that purported to ban the sale of quote-unquote fakes, but he did nothing to enforce that and actually charged an additional fee to vendors who sold counterfeit goods. He simply told those vendors to hide the goods and if they were asked for counterfeits to produce them at that time. We ultimately filed civil suit against this flea market owner and worked with the authorities, who then brought a criminal action against him. We were able to obtain a multi-million-dollar judgment against the flea market owner. The federal authorities had a criminal forfeiture that took essentially all of his property, and the flea market owner, I should say former flea market owner, is now completing the first year of a three-year jail term.
Okay, let's talk about monetary remedies. There are treble damages available under the Lanham Act for willful violations. For example, the True Religion cyber squatting case. The court awarded $863.9 million in statutory damages for willfully counterfeiting the True Religion trademark.
And one of the issues that we've dealt with is something similar to this, where we obtained a $257 million judgment on behalf of one of the brands that we represent. And in these types of cases, before filing the case, one of the considerations needs to be, how are we going to collect on the money? There are ways of doing that. There are ways of setting it up so that assets can be seized ex parte and done very quickly, but that needs to be considered before the suit is filed, and certainly before the offending websites have noticed that the suit is either in the works or is actually filed.
Mm-hmm. So as Patrick just mentioned, you can collect this huge damages award, but the problem is these counterfeiters have international bank accounts, generally outside of the United States court processes. So what can you do? The Lanham Act provides for an ex parte order to freeze assets. This includes foreign financial institutions. This is available once personal jurisdiction is established. And this results in freezing credit card companies and payment processors from continuing these transactions. ICE had a seizure of $896,000 in proceeds from the online sale of sports apparel manufactured in China due to online payments processed via PayPal, even though the funds were being held at Chinese banks.
And I'll state, PayPal is actually excellent to work with on this front. They understand what's going on. They want nothing to do with it. So coordinating with PayPal, they're very, I wouldn't say receptive, but they understand their role in the process, and they certainly want to work with mark holders and brand holders. And strangely enough, Chinese banks are also getting better to work with. Initially, they wanted nothing to do with U.S. enforcement actions, wouldn't turn over funds. There's still a little bit of hesitancy on that, but they're getting better than they were just a few years ago.
Yes.